Yes, sorry, there was a problem with the internet connection. My sincere apologies. Yeah, so I was making the point that I was just trying to recapitulate what we did at our last meeting, what was shares. So just in a very quick fashion, for the sake of those who might have missed that class, we said that shares refers to the interest that a person has in a company. Shares are movable, or they are not immovable property, as it were. You can make a will in respect of shares. You can also gift shares. We said that shares are actually shows in action, not shows in possession. If you have a grievance against a company, you go to court. You don't just resort to self-help measures by taking possession of properties belonging to the company as a way of enforcing your rights. Then again, we also noted that in Ghana, we operate what we call no power value share concept, meaning that when companies register with shares, they don't have what we call nominal value, nominal price. And that at every point in time, the actual price of a share or value of a share is determined when the shares are being issued, or when, for whatever purpose, we need to know the value of the shares, and it is so determined. We also made the point that shares, when issued, must bring money to the company. So shares should be issued for valuable consideration. And we noted that the most preferred way of paying for shares is by cash. However, where you are not using cash, then the law says that within 28 days of being issued shares for consideration other than cash, the agreement under which the shares were issued not in return for direct cash must be stamped and registered with the registrar of companies, or where there is no such agreement, particulars of the agreement under which the shares were issued without direct cash should also be duly stamped and disclosed to the registrar of companies. Then again, we also noted that the company is at liberty to create different types of shares, different classes of shares, and accord certain shares, certain rights and privileges, which are not enjoyed by those who do not have shares in the relevant category. We said that mainly we have two types of shares. We have what we call the preference shares, and then we have what we call the equity, also known as ordinary shares. And we explained that preference shares can be in respect of either a special right given to shareholder with respect to dividends, so that when dividends, so that a certain amount of dividends are paid to that shareholder at times that profits are made. Or the preference share may be in respect of maybe return of assets when the company, for example, is winding up or anything, and you have assets which are left, and they have to be shared among the shareholders. If your preference share with respect to that, you are going to get yours first before any other person. And we also indicated that there can be various configurations. There can be various, ways and manners in which you give preferential treatment to shareholders by reason of particular set of shares or class of shares which you have given them, so that they have what they call a class rights which they alone enjoy, and no other person who is outside that class of shares and all that. We discussed that. So we want to continue this morning. Let me share the screen of the law, then we move on. Yeah, so we want to continue from section 54, construction of, canons of construction of class rights. So just before I share the screen, I was explaining that class rights are rights which are enjoyed by shareholders having shares within a particular class of shares. So that if we are talking about maybe class A shares and you are not a member of class A shares, you cannot enjoy rights which are meant to be enjoyed by class A shares, and so on and so forth. Now, section 54 of the Companies Act 2019, Act 992, provides rules of thumb or provide certain default principles of interpretation which should be considered when we need to interpret the constitution of a company insofar as it relates to class rights or rights attached to particular shares. And what are these principles? So 54A makes the point that unless the contrary intention appears, a dividend is not payable on any shares unless the company resolves to declare that dividends. Now, this is very important. And last class, we made the point that a dividend refers to a return which a person who has invested in a company by way of shares earns for the shares that he has in the company. And when the company makes profits, portion of the profits are declared as being available to be distributed among shareholders. Now, what you will get as a shareholder from the profit earmarked to be distributed for shareholders is what we call your dividend. So dividend is your share of the profits from the company in which you have shares. And 54A is telling us that as a general rule, and that is why it says that unless the contrary intention appears, a dividend is not payable on any share unless the company resolves to declare that dividend. And this is pertinent when you say unless the contrary intention appears, because don't forget that when we're discussing preference shares, okay, when we're discussing preference shares, a point was made that the company can create, if you look at the section 51, or even like you go back to the very first session, I think 42, when we started discussion of shares, the point was made with respect to section 42 that let's look at the 42.2, the number of shares in a company and the rights, my emphasis is on the second part, and the rights and liabilities attaching to the shares are dependent on the terms of issue. So section 42.2 contemplates what section what section 54 is talking about. 54 is saying that unless the contrary intention appears, and as we saw in looking at the section 42.2, that the rights and liabilities attached to shares are dependent upon the terms of issue. So if in issuing maybe a preference share, it was agreed and so reflected in the terms of the issue of that share that maybe a shareholder will be given a certain amount of money as dividends at certain intervals, then regardless of whether the company has declared dividend or not, such a shareholder will be given such a dividend because that is what the terms of the issue of his shares stipulate. And this is consistent with section 42, subsection 2, as we have mentioned. And of course, that is the exception. So that is a very limited scenario. Otherwise, the general position of the law is that a dividend is not payable on any share unless the company has made a resolution to pay dividends. Now, implication of section 54A is that where you do not fall within the exceptional situation, which we have just explained, and it is just the default rule, the general position, which applies to you, what it means is that being a shareholder, you do not have the power, you do not have the right to insist that your dividend should be paid to you, especially so where the company has not made any such declaration or has not passed resolution to declare dividends. Your right to demand dividends, according to this general position of the law, 54A, arises or accrues only where a resolution has been passed that dividends is declared. And then if you don't get yours, then you have a legal right maintainable against the company. So let us keep that in mind, please. Another principle of interpretation, which 54 tells us is in the B. Unless the contrary intention appears, a fixed preferential dividend payable on a class of shares shall be cumulative. In other words, a dividend is not payable on any shares, ranking subsequent to that class of shares until all the arrears of the first dividend have been paid. So what section 54B is telling us is that as a general rule, where a person has a fixed preferential dividend, and what do you mean by fixed preferential dividends? So let's say that if giving you preference share, and we say that, okay, you are entitled to 20% fixed preferential dividends of either the value of your shares or 5% of profits or anything, however it is configured. But the bottom line is that for you as this particular preference shareholder, fixed preferential shareholder, there's a specified amount of dividend which you are entitled to. Now, what that means is that you have an assured sum of money or an assured percentage, which is your dividends. And for that matter, if in a particular year, the company has made profit, but the profit is not enough to pay for your fixed dividend, and only maybe portion of your fixed dividend can be paid as a result of the limited profit declared as dividends. Now you will pay that, the company will be owing you because you have a fixed preferential dividend and they did not finish paying you all that you're entitled to. Now, next time profits are made and dividends declared, Section 54B is saying that you will have to be paid your unpaid arrears from the last season of dividend, which you didn't get the full spectrum or the full complement of your dividend. Before you are paid the full dividend you are entitled to this current season, in which dividends have been declared again. And you have to get that before any other shareholder will actually get his or her dividends. So let us keep that in mind. And that is still the position, even if some preference share is created after yours. then the position of the law is as long as the company owes you from the previous season that dividends were declared and couldn't pay all that was due, you have repaid yours first before any other person whose preference share might have been created subsequent to you will get his dividends paid. And that is why we say that yours is cumulative. Cumulative means that it builds up. You don't lose the unpaid part when dividends were declared because it was not enough. Now let's look at 54C. But let me be quick to add that, just as we saw from the 54A, all that 54B is also doing is setting the general rule, and then it makes room for an exception to be created. So let's keep that in mind. See, unless the contrary intention appears in the winding up, arrears of a cumulative preferential dividend, whether or not earned or declared, is payable up to the date of actual payment in the winding up. Yeah, so let us also keep that in mind. So what is winding up? Winding up is usually what we call the members voluntary winding up. And members voluntary winding up will mean that the company is solvent. Being solvent simply means that the company has the ability to pay its debts and liabilities as they arise or as they fall due. So the company is solvent, usually within 12 months, preceding the decision or the resolution to actually wind up or to fold up the company. So the company is reasonably in good health financially. And because the company has good financial health, if you had no preference share and there's an arrears, what 54C is saying is that despite the fact that the usual season for paying your dividends might not have arrived, insofar as the company is embarking upon a winding up, you are entitled to be paid. You are entitled to be paid whatever dividends that, according to the terms of issue, you are entitled to at the date that they decided to make payment as part of the winding up process. 54D, if a class of shares is expressed to have a right to a preferential dividend, then unless the contrary intention appears, that class does not have a further right to participate in dividends. So let's keep this in mind. We have made the point that we can have a preference share in respect of payment of dividends, okay? In which case, whenever dividends are declared, you as a preference shareholder in respect of dividends, you will get your dividends paid before any other shareholder will get dividends paid. Just a second, let me. Yes, thank you. You get your dividends paid before any other shareholder will get his dividend paid. Now, 54D is saying that if you are a preference shareholder with respect to dividends, the general rule is that when you have paid your preferential dividend and all other shareholders, that is equity ordinary shareholders, have also been paid their dividends and all that, and there is still dividends left, we still have surplus dividends, and we are going to share for the ordinary or equity shareholders. Because you are a preference shareholder with respect to dividends, you will not be entitled to participate in the surplus dividends. Now, mind you, we are not saying that all preference shareholders are excluded. No, we are talking about particular type of preference shareholder. This preference shareholder is with respect to dividends. We have preference shareholder which is not respect to dividends, right? Their preferential treatment may be in other things, maybe return of income or asset. Now, where you are not preference shareholder with respect to dividends, if there's a surplus dividends, you will participate in the distribution of that surplus dividends. But if you are preference shareholder with respect to dividends, once you get your preferential dividend, that is all for you. If millions are left, you are excluded. You are a non-participating preference shareholder. (54)(e), if a class of shares is expressed to have preferential rights to payment out of the assets of the company in the event of winding up, unless the contrary intention appears, that class does not have a further right to participate in the distribution of assets in the winding up. So this is another variation. The 54D, we're talking about preference shareholder with respect to dividends. I will say that for them, once you get your preferential dividends, you're excluded from participating in any surplus dividends. Now, 54E is saying that if your preferential status is with respect to assets of the company, now when the company has come to an end or the company is winding up, you paid all creditors of the company and all those that the company owe. We've paid everybody. So what is left is for us to distribute the remaining asset for shareholders. Now, if you are a preference shareholder with respect to payment out of the assets of the company, you will get your agreed or your preferential share of the assets. You get yours first. Now, when you have been given yours, then 54E is saying that you are excluded from the remaining assets. And then somebody will be asking, how do you know we have a remaining asset? Okay. Now you're a preference shareholder. So you gave money for your shares. And your preferential treatment relates to payment out of the assets of the company. The company is winding up. All creditors have been sorted out, okay? We still have significant assets left. Now we sell the assets, we raise money, and we pay you the amount of money which your preference share represents. We have done valuation to know the value of the shares of the company. So we know how much your shares is worth. And then you pay you the money for the full complement of your share, because that is what the terms of issue says. Now we come to other shareholders. We know the number of shares that they have, and then we know how much the shares are worth. So we pay them how much is due them in proportion to the number of shares which they have. Having paid everybody in that manner, we still have significant amount of money left. So that is the surplus assets we are talking about. Now, if you are a preference shareholder, you are not supposed to actually participate in this surplus of assets, which is going to be shared for the other shareholders. So that is the point we are making. Then 54F, in determining the rights of the various classes to share in the distribution of the property of the company on winding up, consideration shall not be given unless the contrary intention appears, whether or not the property represents accumulated profits or surplus, which will have been available for dividend, while the company remain a going concern. Now, this is 54E is pertinent, and it has to be appreciated within the broader context of the law on dividends. as will be seen from 54A to E. Now, what is happening is this. It is possible for the company to, we made the point that dividends is not available until it is declared. So the company has made a profit of, let's say, 1 million Ghana cedis. Then the company decide to distribute only half of that as dividend to shareholders. So only 500,000 of the 1 million is going to be distributed. The other 500,000 is actually going to be put into the surplus of the company. It's going to be put in surplus of the company. It's not going to be shared. So it's available in the company. Now, one will argue that that money being profit should form part of the dividends. And if you are a preference shareholder with respect to either dividends, your preference shareholder with respect to any other thing, then part of what is supposed to come to you is what goes into what have been actually saved by the company as part of its surplus and so on. Now, 54F is telling us that it doesn't matter when the company is actually winding up or is, is being folded up, and we need to actually determine how much of the company's remaining property should be given to who. We will not actually concern ourselves about how the property actually came about in terms of it being as a result of massive saving from profit, which ought to have been declared as a dividends and were not declared, or just a plowback or something to the company. We are not going to be concerned about that. So that is the point about section 54F. Now, section 54G also said that subject to this section, the shares rank equally in all aspects, unless the contrary intention appears. So the general rule is that shares of the company are equal. There is no discrimination between them. And that is very important. That is to say that if preferential status is not accorded, you don't artificially have to force one. The company can create all manner of preferences, but in the absence of that, then the general rule is that all shares are to be treated equally for all purposes. So let's keep that in mind. Any question before we move on? Shares are not difficult, but a bit technical. And that is why I take my time to explain every minute aspect of the law to you. If you have a question, let me know. Raise up your hand before we move on. Check. Okay, so no question, we move on. Issue of share certificates. If you have a share in a company, the most obvious evidence of the share that you have is what we call your share certificate. Of course, for many years, this used to be very important. But as we notice, over time, for example, as we come to have technology, we come to have digitization and all that. Some of these old doctrines begin to acquire a new meaning. And that is why section 55(1) of Act 992 makes the point that subject to Central Security Depository Act. And then let me say a word or two about this legislation. This legislation, Central Security Depository Act 2007 at 733, it introduced the concept of dematerialization of shares. No, dematerialization of shares and share certificates simply means that under a regime established under Act 733, where a company has got its shares being amenable or subject to this new regime, especially companies which are going to have their security traded in the stock exchange and all that, you have to migrate from the old system where you gave paper share certificates to your shareholders. You migrate to non-paperless form, dematerialization, so that instead of using paper, you are going to rather assign digits. You are going to assign numbers to the shares which your shareholders have. And this is very important. And of course, for good reason. If you have shares which are being traded in the stock exchange, secondary market and all that, you cannot, every now and again, when someone has purchased a share, you go and do paper transfer, or you have to go and issue a new paper certificate. It's not practical, and that is why the dematerialization concept is very important. And that is what the Central Security Depository Act is trying to achieve for us. So let us keep that in mind. So having said that, Section 55(1) is saying that subject to Central Security Depository Act 2007 at 773, a company shall, within 2 months after the issue of any of the shares of the company, or after the registration of the transfer of share, deliver to the register holder of the share a certificate certified by one director and the company secretary, indicating information which have been adumbrated in paragraph A to C. And what are those information? A, the number and class of shares held by the holder, and the definitive numbers of the shares. The definitive numbers of the share, meaning that the company is registered with certain number of shares. Let's say that the company is registered with maybe 100,000 shares, okay? And let's suppose that the company has already issued out 10,000 shares. So now the company is going to issue 1,000 shares more to you. Now, when you are giving the certificate, section 55A is saying that on your certificate, you have the definitive numbers of your shares. So before yours is being issued, already 10,000 has been issued, and now you are being given 1,000. Okay, so your definitive number will start from 11. I mean, to start from 10,001, 10,002, 10,003, and your shares will end at 11,000 because you are being given 1,000 and already 10,000 have been issued. So that when we take the registered number of shares of the company, which is 100,000, we can say that 11,000 have been issued, 10,000 have been issued already, and then you were given 1,000 more. So that way in that order. The certificate should also indicate B, the amount of money paid on the shares and the amount remaining unpaid. So this is also crucial because when the company is going through liquidation or something like that, a liquidator is appointed, and as he goes through the books, if some shareholders will have been called to come and make payment, it will be in respect of those shareholders who were owing the company because they had not paid fully for the shares which have been issued to them. And when it gets to that stage, your best evidence as a shareholder will be the information which you have on your share certificate. And that is why, if you have not finished paying for the shares issued to you, the law says that the amount remaining unpaid should be stated on the face of your share certificate. And C, the name and address of the registered holder. So your name and address should be stated. And the address here is not only your postal address now, your digital address will also be important. And of course, now that we have a national identification system, for purposes of identity and also checking fraud, I'm sure that the current practice of companies will be to ensure that the name that we put on the certificate of the shareholder is consistent with the name on the person's national ID card. So that way, we are able to check any possible fraud which may happen in future. Now, what happens where you lose your share certificate, or where there is a mutilation, or where it is lost? Maybe fire has burnt it and so on. The company, at the request of the registered holder of the shares, shall renew the certificate on payment of a fee prescribed by the company and on the terms as to evidence and indemnity and the payment of the out-of-pocket expenses of the company of investigating evidence that the company may reasonably require. So shareholders are supposed to be responsible, of course, just like the national identity card and the voter's ID card. If you lose it, when you go, you have to pay a token before you'll be given a reissued card. In the same vein, if you're a shareholder and you lose your certificate, you're entitled to have it reissued, but you need to pay the prescribed fee by the company. And not only that, if investigation will have to be made regarding the allegations that you have made with respect to how you lost the certificate or how it got destroyed, those who are going to do that will have to pay by the company, and you will be made to bear that as well. So that is the indemnity that we are talking about in terms of the subsection 2. Now, where there is a default on the part of the company in complying with this section, the company as an entity and officers responsible who did not do what is expected of them are liable to pay to the registrar an administrative penalty of 50 penalty units. So the law says that within 2 months, you have to issue the certificate after issuing the shares. Now, 2 months have elapsed, you are not doing that. Now, let me emphasize this point, because I told you there are some cases before the courts which, in a sense, center on some of these basic things, that somebody was given shares. Of course, in this particular case, not the share certificate, but it has to do with where the shares were issued for non-cash consideration for in-kind payment, then agreement is made. And if you look at the law, which we discussed last week, that the agreement under which the payment was accepted in non-cash form for the shares will have to be duly stamped and then delivered to the registrar of companies and all that. Now, I think that is supposed to be like 28 days or so if you look at the law. Question is, where the agreement is not so stamped and is not processed in the manner stipulated by the law, who should suffer for that? Is it the shareholder or the company? Yeah, so these matters, they seem simple and elementary, but if you don't pay attention to them and learn them well in practice, they will work some difficulties for you. And that is why the subsection 3 is saying that where there's non-compliance with respect to the issuing of the certificates and all that, the competent officers involved are supposed to be punished. And they are punished by the registrar of companies. And that is why the punishment prescribed there is the administrative penalty. So administrative penalty, unlike the, the fine, administrative penalty is imposed by the registrar of company. It doesn't have to go to court for the court to make determination that you are in default. No. The office of registrar of companies will make its own finding as whether you have flouted the law and impose this penalty on you. That is why it's administrative. Now, where an application is made to the court by a person entitled to have the certificate delivered to that person, then subsection 4 says that the court may order the company to deliver the certificate. It may require the company and that officer to bear the cost of an incidental to the application. Of course, you as a shareholder, you also need to be responsible. After all, you have put your money in the company, isn't it? And once you put your money in the company, you need to make sure that you have a reliable evidence anytime, any day, which you can show to demonstrate that, yes, you actually acquire shares in the company. Therefore, when the law says that within 2 months they're supposed to give it to you, 2 months have elapsed, they haven't given it to you, and you sit there, you don't do anything, that is not being prudent. That is actually being irresponsible about your investment. And that is why the law says that you can also make application to the court and get the court to compel the company to actually give you the certificate. And once you go to the court, going to court is not free. You may have to hire a lawyer to do that for you. You may have to incur certain expenses. So all those costs involved, the court will order the company and then the officer who actually neglected his duty in bringing about this state of affairs to bear that. So let us keep that in mind. Now we know what is contained in the share certificate. We know the content, and you know whose duty it is to ensure that it is actually delivered and all that. The next pertinent question is that, what is the legal consequence? What is the effect of this share certificate? In other words, what is the legal value of the share certificate? What does it signify? So that is what we want to turn to now. So we want to look at section 56 of Act 992, effect of share certificates. Now, according to section 56, statements made in the share certificate under the common seal of the company or as certified by 2 directors and the company secretary of the company are prima facie evidence of the title to the shares of the person named in the certificate as a registered holder and of the amount of money paid and payable on the share certificate. So let's pay attention. It is saying that it is prima facie evidence. So at this stage, level 300, level 400, when we say that something is a prima facie evidence, I want to believe that you understand what it means. That is to say that it is not conclusive. It is rebuttable. That is to say that what the share certificate is will be taken as true in absence of any contrary evidence. So that is what it means by saying it is a prima facie evidence. So prima facie evidence that whoever is stated on the face of the share certificate is the one who actually has those shares. And then amount of money stated as the money paid is actually that which will be taken by the court as the position and not any other. So let us keep that in mind. So it's prima facie, it's not conclusive, it is not irrebuttable. So last 50 says to, where a person changes a position to the detriment of that person, in reliance in good faith on the continued accuracy of statements made in the certificate, the company is stopped in favor of that person from denying the continued accuracy of those statements and shall compensate that person for the loss suffered by that person in reliance on those statements and which that person would not have suffered had the statement been or continued to be accurate. So remember the principle of estoppel, right? Section 26 of the Evidence Act, we also come across estoppel by conduct and so on. Now here, Section 50 says to is telling us that if someone has presented share certificate to you, okay, and remember, share certificate can be used for so many things. It can be used as a security to give someone a credit. It can be used for so many other transactions. So a person brought a certificate to you. You look at the certificate and you became convinced that the person has got certain value or has got certain assets. So on the strength of what you saw in the certificate, you decided to do a certain transaction with that person. And it turns out that whatever was stated on the certificate was actually not true. And for that matter, you have suffered a certain loss. So that is what Section 50 says so is talking about, that because you rely upon what the certificate says and you have suffered a loss, you are going to be compensated by the company. It is a company which is responsible for actually ensuring that the information contained on the certificate is accurate. So where it turns out that it is not accurate and you have suffered a loss by your reliance on it, you are supposed to be compensated for by the company. So let us keep that in mind. But there are a number of old case law which illustrates various situations which could arise with respect to the share certificate. Maybe we'll mention the case of a Blumenthal against Ford, a very old case, but we mentioned it 1896. It's Blumenthal against Ford. Let me put it here for you. Blumenthal. Implementer against fraud. Decision. Okay, so implementer against fraud. The appellant lent money to a limited company upon the security of a promissory note on the terms that the company should give him fully paid up shares as collateral security. The company handed to him certificates for shares, which stated on the face of them that the appellant was a registered holder and that the shares were fully paid up. So this is what the certificate said, implementer against fraud. As a matter of fact, the shares were shares which had never been allotted and nothing had been paid on them. So mind you, when we were discussing session 55, we came across, we came across the fact that the information on the share certificate should actually include the definitive number of the shares, okay? So definitive number of the shares, as at the time the shares are being issued, up to this time, how many shares have been issued? We continue from the last number of shares up to whatever number of shares that were being given to you, and in future in that order. So that at every point in time, the certificate would let us know the exact number of shares issued. But as we are seeing from the case of Blumenthal against Ford, what happened was that the shares which have been stated on the face of the certificate involved had never been allotted and nothing had been paid on them. The company was ordered to be wound up. An appellant was placed on the list of contributors. And it was held that the company was stopped from denying that the shares were fully paid up. And that the appellant could not be made liable as a contributor. So we see how the information on the face of the share certificate was taken very serious. Implementer against head. But the court gave certain insights in the opinion of Lord Herschel, who spoke for the, not Lord Hosbury, who spoke for the court. So let's look at what Lord Hosbury said before we look at what Lord Herschel said. And mind you, this was 1897 decision. It was not, it was just around the same time that the case of Solomon and Solomon was decided. So those were the golden age of the company law jurisprudence. And if you look at the name, the same judges who sat on Solomon and Solomon, Lord Herschel, Lord Hosbury, and all that, they are also the same judges in this case. Now, Lord Hosbury had this to say, and I quote, "There is a long series of cases, no one of which is important to quote, because the proposition of law has never been doubted, so far as I am aware, to prove that if a man is induced to act upon a statement and acts upon it because he believes it, and that statement is untrue, it is not competent for the person who has made the representation to say afterwards, I will show another state of facts than that which I represented, and you ought not to have believed what I said. I believe no such proposition can be affirmed upon any authority, and it will be a very lamentable thing indeed for the cause of business, and indeed for the cause of human life, if the law did not recognize the responsibility of persons who make statements and induce others to act upon them, so that they should not afterwards be permitted to turn around and say that what they stated was untrue, and having altered the position of those whom they deceived by statements they made, unquote. Yeah, so Lord Hosbury was re-emphasizing that which has been given a statutory status in our legislation, per section 56(2). But it is also possible for someone to forge the share certificate, so that what the share certificate is saying may not be the accurate thing. So what happened where that is the case? So where the certificate has been forged, will the position be the same? Well, if you look at section 56(3), that subsection 1 and 2 do not affect a right the company may have to be indemnified by another person. So the indemnity here refers to the fact that the company cannot shirk its responsibility of having to pay for whatever loss or whatever expenses which have been occasioned as a result of inaccuracy or as a result of default on its part to issue the share certificate or to ensure that the content is accurate. However, the law also protects the company and says that the company is a juristic person, it's an artificial person, it has a function through instrumentality of human beings. So therefore, if there is any failure on the part of the company too reserves the right and then the power to find out exactly which officer in the company failed to act, for which reason the company is made to compensate someone, is made to bear certain expenses. The company can sue that person and recover the expenses which the company was put to due to the neglect or the failure by that officer from that person. So that is what section 56(3) is reminding us. And that would also include what we're going to talk about, where there has been a forgery of maybe the share certificate as a result of maybe someone not doing what is expected of him. So you look at the case of Rubin against the Great Finger Consolidated. Rubin. Rubin. I hope you're able to see the cases that I put in the annotation. Can you indicate in the chat if you see it? Rubin against Great Finger. Yeah, so in Rubin and another against Great Finger Consolidated, there was a secretary called Rowe, or Rowe, however I want to pronounce it, R-O-W-E. The secretary of the company, that is the defendant company, Great Finger, forged the share certificate of the company by signing the signature of the two directors of the company and fraudulently used the seal of the company The forged share certificate was used to secure a loan from the bank. The company refused to enter the bank on the register as shareholders. The plaintiffs who arranged for the loan repaid the bank and brought an action against the company for the refusal to enter it as a members in its register. It was held that the certificate was false and fraudulent from the beginning to the end. The impression of the seal of the company, though made by impression of the rare seal of the company, was counterfeited and no better than a forgery. The signatures of the directors were forgeries, pure and simple, and every statement in the document a lie. The signatories of the directors were forgeries. Of itself, this fraudulent certificate will give no right against the company. The fact that it was concocted in and sent forth from the company's office, and the company secretary could not give it an efficacy it did not intrinsically possess. The secretary could have no authority to guarantee the genuineness or validity of a document which was not the deed of the company. So, and what the court was saying is that, yes, once there is evidence to show that the certificate appears to have authentic indicia or marks of what is used by the company, it's still not going to be taken at face value because the system has been rigged. So that is the point about ribbing against Great Finger Consolidated. And of course, we have mentioned that Section 56(3) maintains the right of the company to get indemnity against whoever was responsible for the inaccuracy in the share certificate, which has occasioned a loss to the company. So on that, we can look at the old case of Corporations of Sheffield Corporation against Barclays and Co. Limited. I mean, these provisions, I should say, are actually trying to reenact or trying to codify the ratio decidendi of these cases. So the cases are being mentioned, not because they state the law, but because they give a practical illustration of how these provisions have actually played out in concrete set of facts. So that is the point of citing these cases. The most important authorities are the provisions of the law. So let me give you this as well. Corporation of Sheffield Corporation. Please. Yeah, so in Corporation of Sheffield Corp against Barclays and Company Limited, 1905 AC 392, the Lord Chancellor at the time, again, the same Lord Hosbury. And as I told you, the period from the ending of the 19th century to the very beginning of the 20th century was actually a golden era of the company law, jurisprudence, or case law. So in Corporation of Sheffield Corporation, the Lord Chancellor Hosbury made the point. In this case, two persons, Timber and Honeywell, were joint owners of corporation stock created under the Local Act of Parliament. Timber, in fraud of Honeywell, forged a transfer of the stock. So stock is the same as if you like the shares, and borrowed money on the security of the stock, which the transfer was supposed to have transferred. A bank which lent the money sent the transfer to the proper officer of the corporation and demanded, as they were entitled to do, if the transfer was a genuine one, that they should be registered as holders of the stock. The corporation acted upon their demand. They transferred the stock into the names of the bank, and the bank, in ordinary course, transferred it to the holders for value. The corporation also, in ordinary course, issued certificates, and the holders of these certificates were able to establish their title against the corporation, who were stopped from denying that those whom they had registered were the stockholders entitled. Honeywell, after the death of Timber, discovered the forgery that had been committed and compelled the corporation to restore the stock. And the question in the cause is whether the corporation has any remedy against the bank who caused them to act upon a forged transfer, and so render themselves liable to the considerable loss which they have sustained. Now, apart from any decision upon the question, it being taken for granted that all the parties were honest, as you have thought that the bank were clearly liable. They have a private bargain with the customer. Upon his assurance, they take a document from him as a security for a loan, which they assume to be genuine. I do not suggest that there was any negligence. Perhaps business will not go on if people were suspecting forgery in every transaction. But their position was obviously very different from that of the corporation. The corporation is simply ministerial in registering a valid transfer and issuing fresh certificates. They cannot refuse to register. And though for their own sake, they will not and ought not to register or to issue certificates to a person who is not really the holder of the stock. Yet, they have no machinery, and they cannot inquire into the transaction out of which the transfer arises. And his lordship continued. The bank, on the other hand, is at liberty to lend their money or not. They can make any amount of inquiries if they like. If they find that an intending borrower has a co-trustee, they ask him or the co-trustee himself whether the co-trustee is a party to the loan, and a simple question to the co-trustee will have prevented the fraud. Then you go on and on and on, and his lordship will just make the point that yes, once the company has been put in the way that we have talked about, the company is entitled, if he has the means, to identify who was responsible to actually get indemnity, as Section 56, Section 3 is also contemplating. Now, in the same decision, that is in the same Corporation of Sheffield Crop against Barclays, Lord Davey was also one of the judges who decided Simon and Solomon. He too was on this panel, and he too has a few words to add, which illuminate what we are seeking to understand with respect to Section 56(3). So I quote portions of Lord Davey's opinion, quote, On these facts, the Lord Chief Justice, who tried the action, has held that the appellants are entitled to be indemnified by the respondents against the liability which they have incurred. But his judgment has been reversed by the Court of Appeal. Before referring to the numerous authorities which have been cited, I will first state the grounds upon which I have come to the conclusion that the Lord Chief Justice was right and that his judgment should be restored. Not much turns upon the particular provisions in the Corporations Private Act of 1883, as with the transfer of the debenture stock or the keeping of the register or the issue of certificate of title. They, for the most part, follow the lines of similar provisions in the Companies Clauses Act. I think that appellants have a statutory duty to register all valid transfers and, on the demand of the transferee, to issue to him a fresh certificate of title with the stock comprised therein. But of course, it is a breach of their duty and a wrong to the existing holders of stock for the appellants to remove their names and register the stock in the name of the supposed transferee, if the latter has in fact no title to require the appellants to do so. And it makes no difference that the appellants were not aware of the invalidity of the transfer or could not, with reasonable diligence, have discovered it. I am further of opinion that where a person invested with the statutory or common law duty, a person invested with the statutory or common law duty of ministerial character is called upon to exercise that duty on the request, direction, or demand of another. It does not seem to me that matter which word you use, and without any default on his own part, act in a manner which is apparently legal, but is in fact illegal and a breach of the duty, and thereby incurs liability to third parties. There is implied by law a contract by the person making the request to keep indemnified the person having the duty against any liability, which may result from such exercise of the supposed duty. And it makes no difference that the person making the request is not aware of the invalidity in his title to make the request, unquote. Yeah, so that is enough context for us as far as Section 56, subsection 3 of our Companies Act 2019, Act 992 is concerned. So as I indicated to you, these provisions actually try to enact or codify the ratio dissidenda in these old cases. Now, 50 says for the provisions of subsection 1 and 3 do not apply in cases of shares which can be transferred through a scheme of a central depository under the Security Depository Act 2007 at 733 or any other enactment. Yeah, so as we have indicated, companies that have actually signed on onto the paperless system under Act 733 are actually exempted from all that we have been discussing with respect to shares certificates. So let us keep that in mind. So in absence of questions, we move on. Okay, so in absence of question, we want to discuss reserve liability. Section 57. What is this concept of reserve liability? A company limited by shares may, by special resolution, determine that a portion of the unpaid liability on its shares which has not already been called up shall not be capable of being called up except in the event and for the purpose of the company being wound up. So this is the concept of reserve liability, and this is how it works out. We have noted that when shares are issued, they do not have to be paid upfront completely. Let's say that if you are giving 1 million shares, and maybe at the time of issue, each share is worth 1 cedi. Since issuance of share is a matter of agreement between the company and then a prospective shareholder, the terms of issue may be crafted in such a way that the shareholder pays for only half of the value. And then the company will say that the other half be paid in 3 years' time or be paid in 12 months' time. So we'll be giving the shares over by having fully paid for all of them. Now, under the terms of issue, you are supposed to have the unpaid one paid within a defined period, or when the company has actually served a demand notice of you. And when the company serves a demand notice on you to come and pay, you call that they have made a call on you. They've made a call on you, not telephone call. That is a technical language in shares. They've made a call on you. They have made a demand on you to come and pay the unpaid liability. Now, the company may resolve using special resolution. And just in case you forgot, a special resolution is a resolution which is required, notice is required to be given before the meeting. And then when the meeting is held, you're supposed to secure 75% of all those who are present and then eligible to vote. So that is a special resolution. So the company may pass a special resolution to the effect that a certain fraction or portion of monies which shareholders are supposed to pay for shares they have been issued, which they haven't paid because the company has not actually called upon them to come and pay. The resolution can say that, okay, a certain percent, let's say that we are passing a special resolution to the effect that 70% of all monies which have not yet been paid by shareholders who have been issued shares, 70% of that is not going to be demanded now until the company is being wound up before they'll be called upon. Now, where the company passes such a resolution trying to reserve liability, the company is, of course, the company will not do that unless the company is in a comfortable lead as far as its capitalization or its funds are concerned. The company has enough money to be able to run so that comfortably it will not need to call upon shareholders who have not fully paid for the shares that they have been issued to come and pay the unpaid balance. Then the company can actually use that as a buffer, as something that it will fall on when it's really needed. So that is the point about section 57, the resolution to reserve liability. Now, where a resolution to reserve liability is passed, that portion shall not be capable of being called up, except in the event of a purpose stated in that subsection. Yeah, so let us keep that in mind. Now we come to my favorite topic in shares, what we call the doctrine of capital maintenance. The doctrine of capital maintenance. Doctrine Are you able to see the things I'm writing? Yeah, so the doctrine of capital maintenance, very important doctrine. And it is important that we understand it well. So what does it say? What does the doctrine of capital maintenance say? Now, as the phrase itself suggests. Now, let's start from this way. We have noted that shares are issued with the aim of raising money for the company. Shares are not issued just for fun. Okay, so that is a starting point. Now, if shares are issued with the aim of raising money for the company, then when the company has raised money by way of issuing shares, the money so raised should not be used for any purpose, but just for the operations of the company. And that is the basic idea of capital maintenance. And this doctrine seeks to protect interests of creditors, as it seeks to ensure that the company's capital is not dissipated or returned to its shareholders until all liabilities and claims against the company have been settled. And as I have indicated, the point about capital maintenance is that the capital contributed by shareholders, right, as shares are given to them and they pay money, that forms a security for the company's creditors. Now, creditors of the company, either those who give direct loan to the company, as in debenture holders, other lenders, or other trading creditors, those who give goods to the company on credit basis, they deal with the company in the sure knowledge that the company that they're dealing with is a going concern. And for that matter, it is safe and reliable for you to loan money to the company because it is robust, it's got assets, and it's turning around its assets to generate profits, and it will have the ability or means to always pay for its debts, as it were. So the doctrine of capital maintenance is usually framed around two main pillars. So we have prohibition against reduction of capital, except in circumstances permitted by the law. And the second pillar is restriction on distribution of dividends to shareholders from sources other than profits. So basically, that is the idea. And the common law, we will go to the case of Trevor and Whitworth. Trevor and Whitworth. Trevor and Whitworth, a 19th century decision, is the case which, if you like, in terms of jurisprudence, propounded what we will call the capital maintenance doctrine. And what happened in Trevor and Whitworth? Trevor and Whitworth, let me put it here. Trevor, so 1882 decision. Now, in Trevor and Whitworth, a company bought back almost a quarter of its own shares. You give shares to shareholders so that you get money. But here, what happened was that the company was buying shares that had already given to shareholders back. Now, during the liquidation of the company, one shareholder applied to the court for the balance of amounts owed to him after the buyback. And the Court of Appeal held that that shareholder should be paid. So an appeal was lodged to the House of Lords. Mind you, until the last few years when the UK Supreme Court was set up, the judicial committee of the House of Lords was the highest court in the UK. The House of Lords at the time held that buying back or buyback of the shares was Travaris, the company. And with respect to capital maintenance rule, Lord Herschel made the following statements, and I quote, "If the claim under consideration can be supported, the result will seem to be this, that the whole of the shareholders, with the exception of those holding 7 individual shares, might now be claiming payment of the sums paid on their shares as against the creditors who had a right to look to the money subscribed as the source out of which the company's liabilities to them were to be met. And the stringent precautions to prevent the reduction of the capital of a limited company without due notice and judicial sanction will be idle if the company might purchase its own shares wholesale and so effect the desired result. I cannot think that the employment of the company's money in the purchase of shares for any such purpose was legitimate." Then Lord Herschel will continue in Trevor and Whitworth again, quote, "One of the main objects contemplated by the legislature in restricting the power of limited companies to reduce the amount of their capital as set forth in the memorandum is to protect the interests of the outside public who may become creditors. In my opinion, the effect of these statutory restrictions is to prohibit every transaction between a company and a shareholder, by means of which the money already paid to the company in respect of his shares is returned to him, unless the court has sanctioned the transaction. Paid up capital may be diminished or lost in the course of the company's trading. That is a result which no legislation can prevent. But persons who deal with and give credit to a limited company naturally rely upon the fact that company is trading with a certain amount of capital already paid, as well as upon the responsibility of its members for the capital remaining at core. And they're entitled to assume that no part of the capital which has been paid into the coffers of the company has been subsequently paid out, except in the legitimate course of its business, unquote. Yeah, so The point Lord Herschel and Trevor and Whitworth is saying is that once the company has raised money by issuing shares, the money so raised should remain in the company, should be conserved in the company. It should not be depleted. The only permissible way by which money raised by the company from shares may be depleted through the usual trading loss. Of course, the company is involved in business. So in business, we make profit, we make a loss. That one, there's nothing wrong about that. And as Lord Herschel said, no law can actually prevent that. Once the company is going to engage in business, the company may make a gain, may make a loss. That is fine. However, the company should not make a conscious effort to take money out for things other than normal trading, which may lead to part of the capital being lost. So that is the point Trevor and Whitworth actually represent. So let us keep that in mind. So with that said, let's come back to our legislation, and we would like to start from section 58. Of course, we will be doing back and forth. We'll go to some section 68 at some point, and then we come back as it were. So maybe let's delete this. Yeah. So section 58, the sectional subheading prohibited transaction in shares. And as I said, it is indicative of what is known at common law or in corporate law jurisprudence as the doctrine of capital maintenance. So section 58(1) is to the effect, and I quote, except as provided in this act, a company shall not, A, alter the number of its shares or the amount of money remaining payable on those shares. B, release a shareholder or a former shareholder from a liability on the shares. C, provide financial assistance, directly or indirectly, for the subscription or purchase of the shares of the company or the shares of its holding. Or D, acquire by way of purchase or otherwise any of its issued shares or any shares of its holding company. Now, let's look at 58(1) again. The chapeau refers to the opening words, if you like, the preamble. Except as provided in this act. Except as provided in this act. Now, what that means is that, of course, there has been a drafting improvement in this, because if you compare this with the previous section 56, no, in the Repealed Companies Act 1963 at 179, equivalent of section 58 or section 56. So if you look at the wording at the time, it used to, refer to except as provided in this section, but I think that was a drafting error. So this present rendition sounds better. Except as provided in this act, that is to say that all the things which have been canvassed in A to D are mandatory. They must be adhered to strictly. The only exception is where some special dispensation is provided in this Act 992, which permits the things which have been stated in A to D from being tempered with or being done in some other way. That is the only exception. So let's keep that in mind. Now, I want us to take them one after the other and see how they reflect the principle in Trevor and what? The capital maintenance doctrine before we will take specific dimensions of it. So the company is prohibited from altering, that is changing the number of shares or the amount of money remaining payable on those shares. Of course, with respect to the first part, altering the number of shares per se, one will argue does not really mean much as far as capital maintenance doctrine is concerned, because if you talk about number of shares simplicity, you haven't said anything. But we have registered number of shares, what you call the authorized number of shares, and then we have the issued shares, number of issued shares. If you say that the company shall not alter the number of its issued shares, of course, those have been given out, so that is fine. But the amount remaining payable on those shares. So I will propose to you that a proper understanding or interpretation of section 58(1)(a) is to understand the number of shares, okay, in that provision as referring to issued number, number of issued shares, right? So here, and that is why you need to come to class. There are certain things you will not see in the books. When you learn on your own, you need to get experienced people to teach you. Yeah, so if you look at the 58 here, right? A company shall not alter the number of its shares. And then you have this ambiguation here, or the amount of money remaining payable on those shares. And I am suggesting to you that a proper construction or interpretation of this provision, the number of shares here should actually be understood as the number of its issue shares. So issue shares here, issue. Let me use the power. So I'm talking about here. Said should have so I'm saying that 58(1) alter the number of its issue shares. And the issue which is being inserted here is an interpretive exercise we are doing. And we're able to do that because of what we have here. Okay? Because of what we have here. That is the amount remaining payable on those shares. If you say the amount of money remaining payable on those shares, then the presupposition is that shares have been issued. So if shares have not been issued, you cannot talk about money remaining payable on it. And if that is so, then 58(1)(a) should probably be understood as alter the number of its issued shares. You cannot, because you cannot change that. So let's keep that in mind. And we have seen that the shares issued represent money. Either they've been fully paid or part of it is remaining unpaid. But even if it's a part remain unpaid, it's still money belonging to the company. And the company can make a call. The company can demand for its payment at any time. And that is why the company is prevented from taking any step which will say that the money remaining payable on the shares should not be paid again. No, if the company did that, the company is violating the capital maintenance doctrine. Then B, release a shareholder or former shareholder from a liability on those shares. Yes. If you have shares and you haven't paid, you cannot be excused from paying the arrears. The company does not have the power to do that. Then C, provide financial assistance for subscription or purchase of the shares of the company. Shares are issued to raise money. And if that is so, how can a company which is trying to raise money by issuing shares give some of its money to people to come and buy its own shares? As the accounts or the scientists will say, that if you cut your tongue and you chew it, you haven't really chewed any meat because it's part of you, isn't it? So in the same vein, a company is trying to raise money by having shares. So if the company decides to give its money to people to come and acquire its own shares, then what money is it raising? Is rather violating the capital maintenance doctrine. As I said, these are the general rules. We have an exception which we'll be looking at as we move on. Okay, then D, the company shall also not acquire by way of purchase any of its issue shares. And this is exactly what happened in the Trevor and Whitworth, which we discussed, and which gave rise to articulation of this capital maintenance doctrine. So you have issue shares, you've collected money from shareholders. Why do you give the money back to the shareholders? If you did that, you are depleting your capital, and that one is frowned upon. So these are the general prohibitions, okay? These are the general prohibitions. But as we noted from the chapeau of 58 or the preamble of 58, that except as provided, right? Except as provided in this act. So the next question, which we'll be exploring, is that are there instances in which the company will be able to do any of the things which is forbidden under 58 1A. So those are the things we are going to be looking at as we move on. Prefect, your class, is it in person or online? I'm talking about your next class so that I'll know what to do. Where's the prefect? The prefect here. Okay. Prefect, yes, you can mute yourself.
Yes, my lord.
Is it in person or is online?
Please, my lord, it's in person.
Oh, okay. Then if it is 12, are you on campus already?
Yes, 12. No, my lord, most of us are doing the class from our respective.
Oh, okay. All right, then let me stop here so that you can go for your next class. Otherwise, I'll have loved to finish this topic. We'll continue next time.
We are grateful, my lord.